Some people don't realise that in 2003, a jury was told that Kathleen Folbigg killed her children because she was frustrated about missing the gym. That was the motive. That was the why. Then it took 20 years and a genetic mutation that occurs in 1 in 35 million people to prove that motive was never real. So what does that actually mean? Well, the law does not require a motive, but it seems that a jury needs one. And that gap between what the law requires and what a jury expects is where wrongful convictions are born. In this episode, we're pulling that apart. We're going to look at what motive is in legal terms and why it has quietly become one of the most powerful forces in a criminal trial, and what happens when it starts doing the work it was never supposed to do. The cases of Lucy Letby, Kathleen Folbigg and Sally Clark sit at the centre of all this. 3 prosecutions where the evidence couldn't prove intent, but motive was used to imply it. In all 3 cases, motive did the work, evidence couldn't, and one of them ended in a statistic so wrong it helped to rewrite the rules. The troubling part, or the part we're going to look at today, is that the legal machinery that produced these outcomes look almost identical, but that's only half the story. Now, you've probably heard it 1,000 times in courtroom dramas, in true crime podcasts, in trials, where the question was asked, what was the motive? It's like a magic key, and without it, nothing makes sense. Because while motive feels essential, it's never been legally required. A prosecutor needs 2 things to convict: the act itself and the intent to do that act. That's it. Motive, not required. It never has been. But in reality, what the law calls for is actus rea or mens rea. Both these are Latin terms for they did it and they meant to do it. The point is what you did and what you meant, not why. Think about it this way. Someone walks into a store, slips a laptop under their jacket and quietly strolls out. Whether they stole it because they were broke, jealous, or they could is completely irrelevant. And that's not my opinion, that's black letter law. Intent must be proved. Motive does not. But now imagine that same trial. The prosecutor tells the jury he was behind on the rent. He was desperate. He had every reason to steal. That's a motive. That's not evidence of the theft itself. But can you feel it? Can you feel how the room shifts in that moment? That's what motive does. It doesn't prove anything, but it changes how everything feels. So if motive is legally irrelevant, why does it feel like it's everything in a real trial? Well, maybe it's because somewhere along the line, psychologists hijacked the courtroom. Modern juries just don't want evidence. They want a story. They want to understand the why of a case. And prosecutors know this. They give juries a reason that feels true, and they make the accused actions make sense. But where the evidence is thin, speculative motive rushes in to fill that silence. That's when it stops being a background noise and starts becoming dangerous. And here's the part people often miss, because investigators also fall into that exact same trap. If an investigator can picture a motive, the suspect suddenly fits the theory of the crime. If they can't, they go looking for one. And if they still can't find one, sometimes they build a theory around a motive that never really was there in the first place. And once that happens, it's impossible to undo. 2 women learnt that the hard way. Now, this is the important part here, because the legal baseline is straightforward. Criminal liability turns on the act and intent. Motive can arise in a trial, but its evidentiary value is narrow. It isn't an element of an offence or something that needs to be proved. Yet, its psychological weight in a courtroom is another matter entirely, because while motive doesn't convict in law, it can convict in the mind of a jury. And this is where it stops being a legal technicality and starts becoming a weapon. No motive weakens the prosecution's case and favours the accused. A plausible motive can make a circumstantial case feel far more compelling than the evidence alone. And in trials where hard evidence falls short, motive doesn't just support the prosecution's theory, it often becomes the prosecution's theory in totality. The gap between a legal standard and courtroom reality is exactly where wrongful convictions take root. In the Letby case, no motive was ever established, and legally it didn't have to be, but the prosecution offered 5 anyway, which raises the question: if motive wasn't legally required, why did they spend so much time building one? That matters, because this wasn't a case where a single coherent motive emerged from the evidence. This was a case where the theories kept coming, each one darker and more elaborate than the one before, and all of them doing exactly the same job, filling the silence where hard evidence should have been. The first theory was almost sympathetic. Letby was seeking a thrill, but that didn't stick. So they reached for something far more clinical, factitious disorder. Still not enough? Then the hero complex. She was saving babies so she could be a hero who could revive them. Each theory darker than the last, and all of them doing exactly the same job. Motive didn't support the case. It was the case. And this is what makes these 5 theories legally dangerous, because a jury only needs to believe one. Now, a prosecutor would tell you these theories serve a legitimate purpose, and they do. They help the jury understand the evidence. Without a why, a string of infant deaths is just a medical tragedy, not a crime. And that's a fair point, in principle. But it collapses in practice. When the evidence itself is disputed, when the medical foundation is under serious threat or challenge, what exactly is motive helping the jury to understand? Because in that moment, motive isn't contextualising the evidence, it's compensating for the fact that there isn't enough of it. Here, motive was used to build an overarching narrative, and that is a crucial distinction, because Letby's conviction is now the subject of serious challenge. A panel of 14 medical experts assembled by Dr. Shu Lee concluded there was no medical evidence to support the conclusion that any of the 17 cases involved were caused by deliberate harm. Which brings us back to a core legal question. If the medical basis of the prosecution's case is now in dispute, then what purpose did all these shifting motives actually serve? Because across the other side of the world, in a different decade, in a different courtroom, and a completely different type of case, motive did exactly the same job. Only this time, the woman it convicted walked free 20 years later. How? Because the motive they built was never there in the first place. I want you to stay with me here, because this next case connects to something much bigger. At first glance, the Folbigg case looks straightforward, but it isn't. It's completely different from Letby's in one fundamental respect. She was exonerated, but the road to exoneration ran directly through the same problem, a motive built on interpretation and not evidence. At the trial, the prosecution's theory was that Folbigg was frustrated and resentful. They argued she smothered all 4 of her children during moments where they intruded on the life she wanted. And the evidence for this? Her diaries. Prosecutors painted a picture of a woman preoccupied with her weight, frustrated at missing the gym, and resentful that motherhood was getting in the way. But the diaries were never a confession. But they were used like one. Let's be honest here for a second. The diaries were never close to a motive, but in the absence of forensic evidence capable of distinguishing smothering from natural infant death, the prosecution needed a why, and the diaries provided it. Now, the This is important because grief, self-blame, and the raw and often irrational things a devastated mother writes in private was all filtered through the lens of a pre-existing theory and framed as evidence of guilt. But let's look at what happened in 2023 because it's important. An inquiry led by the Honourable Justice Tom Bathurst formally dismantled that narrative. Psychological and psychiatric experts concluded the diary entries were what they actually were: emotional release by a bereaved mother, processing unimaginable loss, not confessions, not a window into a murderous mind. And this is the point where things shift, because the decisive blow wasn't psychological, it was genetic. Folbigg and her daughters were found to carry a genetic mutation, a gene associated with severe cardiac disorders and sudden infant death. The mutation occurs roughly in 1 in 35 million people. The deaths that had been attributed to a pattern of deliberate killing had a biological explanation that the original trial never had access to or never properly considered. Because in June 2023, Kathleen Folbigg received an unconditional pardon where her convictions were formally overturned. That's 20 years built on a motive that never existed. Now, Folbigg and Letby are twin cautionary tales about the use of circumstantial evidence and what sometimes is called the pattern matching fallacy. The reasoning goes, too many deaths in the same family or on the same ward cannot be coincidence. Therefore, someone is responsible. Therefore, we need to find that someone. That reasoning feels intuitive, and it can even feel logical. But it isn't evidence, and when it drives a prosecution, motive stops being something that supports the case and starts being something that substitutes for non-existent evidence. The troubling part here is the legal machinery that produced both of them look almost identical. So we have two cases, two countries, 2 decades apart, the same mechanism. Kathleen Folbigg walked free after 20 years because science finally caught up with the law. And in our next case, Sally Clark was acquitted, but the system that convicted her didn't just take her freedom, it took everything else. And she never got it back. Sally Clark was a solicitor in the UK. Her first son, Christopher, died at 11 weeks in 1996. Her second son, Harry, died at 8 weeks in 1998. There was no forensic evidence of murder. There were no witnesses and no confessions. Her friends and family described Sally as a devoted mother. The prosecution had 2 dead babies and nothing that resembled a motive until Professor Roy Meadows stepped through the door and took the stand. Now they had a motive, only this time they built a motive out of a number. And this is where everything starts to connect to the Folbigg and Letby cases. Meadows told the jury that the probability of 2 sudden infant deaths in a family like the Clarks was 1 in 73 million. He wasn't a statistician. The calculation was completely wrong, and the Royal Statistical Society later said so formally. But the jury heard it first, and the number did exactly what the 5 psychological theories did for Letby and a misread diary did for Folbigg. It filled the silence where actual evidence should have been. That's a motive manufactured by bad statistics. Not a psychological profile, not an emotional narrative, just a number so large it made guilt feel mathematically right. The number wasn't evidence of what she did, it was a substitute for explaining why. There was a second failure in this case. The prosecution's pathologist, Alan Williams, had taken samples during Harry's post-mortem. These tests showed the presence of a bacterial infection capable of killing an infant rapidly. He did not disclose them. Not to the prosecution, not to the defence, and not to the court. This decision changed everything. The results sat buried in hospital records, Well, Sally Clark was convicted and spent 3 years in prison. When they were finally discovered, her conviction was quashed. When the Court of Appeal overturned her conviction in 2003, their language was quite devastating. They just didn't acknowledge that Meadows' statistic was wrong. They called it misleading and unsafe. This is what was at stake, because Sally Clark never recovered. She died in 2007, 4 years after her release. The system didn't just convict her, it destroyed her. And the motive? That did it. A number, a statistic, and that's all it took. So we have 3 trials, 3 different mechanisms, theories, diaries, and statistics. The courts have been clear on this for centuries. In the case of Bamber, the judge reminded the jury of a basic point in criminal law. The Crown did not have to prove a motive, and the absence of one didn't prevent them from convicting. The law doesn't ask why, it asks what and whether you meant it. But let's look at what they share. Each one took something personal. Letby's handwriting, Folbigg's grief, Clark's motherhood, and turned it into proof of murder. Not what they did, not forensic evidence, but who they were. In all these cases, the architecture is identical. Evidential insufficiency, the prosecution couldn't meet the burden on actus rea alone. Motive functioned as surrogate evidence, not a supplement, but substitute. The system didn't malfunction, it worked exactly as it was designed to, and still convicted the wrong person. That's the real lesson here. The danger isn't a rogue prosecutor or a dishonest expert. It's a system running as intended, yet still producing wrongful convictions. Sally Clark's conviction was built on a number. Kathleen Folbigg's was built on a diary entry, and Lucy Letby's was built on 5 theories that kept shifting. 3 different disguises for the same trick. Motive doing the work that evidence couldn't. If you want to see exactly how the pattern was built, how these 2 cases mirror each other almost perfectly, I've linked the video below. It's the second video in this series, and it's where this pattern was first exposed. And if you're new here, this channel exists for this kind of analysis, pulling apart the legal structures that produce wrongful convictions. Not the headlines, but the machinery underneath. And if you've made it this far, honestly, thank you. Leave a comment. Let me know which of these 3 cases you think shows the danger most clearly. I read every comment that I receive. Hit the subscribe button because this series is ongoing, and in the next episode we go deeper. Until next time, I'll see you in the next video.